District Court, right past Court of Appeals, straight to the Supreme Court for an injunction. Ooh-wee. We should all have such privilege in the United States of America to be able to go directly to the United States Supreme Court and get instant relief. Do you see that? Do you see how that worked? Nobody else could get that to happen, but yet it happened. Justice Alito, with whom Justice Thomas joins, dissenting. Shortly after midnight yesterday, the court hastily and prematurely granted unprecedented emergency relief. Proceeding under the All Writs Act, Title 28 U.S.C. Section 1651, the court ordered the government not to remove a putative class of detainees until this court issues a superseding order. Although the order does not define the putative case or class, it appears that the court means all members of the class that the habeas petitioner sought to have certified, namely all non-citizens in custody in the Northern District of Texas who were, are, or will be subject to the March 2025 presidential proclamation entitled Invocation of the Aliens Enemy Act regarding the invasion of the United States by Tren de Aragua and or its implementation. Motion for class certification in case number 125. And this is court number 125 is the year. CV is civil. CR would be criminal. And this is the 59th case to be filed in that court in the Northern District of Texas, Dallas, Fort Worth. And although the court does not specify what it means by the government, it appears that the term is intended to embrace all the named defendants, including the president. CF, compare. Compare Federal Rules of Civil Procedure 65D2. The court did all this even though, bullet point 1, it is not clear that the court has had jurisdiction. The All Writs Act does not provide an independent grant of jurisdiction. See 28 U.S.C. 1651A, permitting writs necessary or appropriate in the aid of a court's jurisdiction. Clinton versus Goldsmith, Supreme Court case from 99. The express terms of the All Writs Act confine the power of a court to issuing process in aid of its existing statutory jurisdiction, which means that, okay, the only way that they can use the All Writs Act is if they have already incurred jurisdiction. However, jurisdiction was not ripe in this particular, an emergency, what was it, emergency injunction. Application for preliminary injunction, temporary injunction, basically a TRO. Okay, so because they skipped the U.S. District Court and obviously skipped the U.S. Court of Appeals and went straight to the Supreme Court, the Supreme Court never had jurisdiction in the case. What happens when a court acts without jurisdiction? Everything's void and moot.